All right, so we're continuing through the list. Now what? What to do when someone dies. And we're going to come to a video that's going to be focused on one point. If you've downloaded it, we're on number 4, and this is going to be dealing with attorneys. There's so much to pack in here that it's going to be its own video. I will tell you, there are circumstances where you have to engage an attorney. There are circumstances where you don't necessarily have to engage an attorney. And then there's some areas where you would be better served to work with one, and maybe you don't in other situations. That said, at some point you may want to talk through the process with an attorney so you better understand what the circumstances are. There are a lot of attorneys, myself included, who will sit down and walk you through a process and not charge you for it, because from my perspective, I don't know what your needs are. And so why would I charge until we have a better feel for what your needs are in your circumstances? In Indiana, if you have to go through a probate process, and we'll talk about probate in future videos, and there's another video that I'll link in the page that talks more deeply about probate, very, very specifically. But if you go through probate in Indiana, you do need to hire an attorney. What I'll talk about from a pricing perspective and fees expectation, I want you to take some notes on, because there is a vast array of difference between what attorneys charge for their services when it comes to probate. I'll give you the basic makeup of how pricing is determined and how you can ask the question, maybe even before the first meeting, of how that works. But an attorney in general might be able to help you understand whether there is a need for probate, whether there's a need to do any other legal documentation outside of probate to transfer assets to beneficiaries or to another account or something along those lines. So it's not a bad idea at some point to sit down with an attorney and just ask them, here's where we are. What do you think about this circumstance, and what would be your recommendation? Now, I will tell you, the first attorney you meet with doesn't have to be the attorney you hire. You need to be able to connect with this attorney and feel like the questions that you have are being answered. You want to feel like you understand what the process is going to look like, depending on what that process is, time frames, expectations for providing material, who has to sign off on what, and things of that nature. So it's important that you feel like you can communicate with the attorney and that you are getting more understanding of the process as you go. We actually have a download, How to Hire an Attorney, and it's appropriate here. There's 5 things we ask you to consider as you're going through the process. How do you start the search? How do you even determine who you're going to talk to? Attorneys use these things called a term called practice areas to kind of dictate, here's what a person focuses on. Now, I'll tell you, there are a lot of attorneys that will say they do probate, but they also do family law, and they do bankruptcy, and they do a whole variety of other things. And sometimes you need someone that has maybe a higher level of understanding or a higher level of focus on the probate process. Different courts do probate different ways. That's to say different counties do probate in different ways. So sometimes it's important to have an attorney that understands Lake versus Porter versus LaPorte versus Pulaski. So there's a link on the page here where you can download the How to Hire an Attorney, the steps to kind of go through and prepare yourself for that process. In the process, we tell you to contact an office, ask a few questions, and one of the things you're going to ask is, what's the charge for, in this case, probate? Now, there are a lot of attorneys who won't quote fees over the phone, and that's fine, but at least understand what their fee structure is based on. So there's basically 3 ways an attorney can do a charge for a probate. I prefer a flat fee, meaning we look at the circumstances and to the best of our ability, we're able to say this is what the total fee is going to be for that process. When I quote people an uncontested, unsupervised probate, my fee is $3,200 all up and in. Now, there's some limitations on that. If it starts to get out of control, if we start to get people arguing and fighting and want to drag it into court, then we have to change the fee structure. But if we stay within the fence lines of unsupervised, uncontested, not a ton of creditor issues that we have to deal with, that $3,200 is, from my perspective, an amount that's an appropriately reasonable fee for the services rendered. And probate's going to take you some time, as we talk about in the probate video. it's going to be a 6-month process at minimum to work through the process, and more often than not leans closer to a year. So just be aware of that as well. It's important that expectations are set for everybody. You understand the timelines. So if you become the person that's in charge, or if you're just a beneficiary, you kind of know what to expect. Would the attorney be willing to meet with more than one person, the whole family, and kind of talk through it? I don't mind that. And actually, I think it's a good idea for everybody to get on the same page. Maybe some people are there physically. Other people may be there through a video call or a telephone call. But at least everybody's hearing the initial message from the beginning, and we can try to at least start with everybody on the same page. I promise you not everybody will stay there over the course of time, but at least we can say we all started in the same place and everybody understood kind of what to expect going forward. Another way that people set their flat rate, they may call it a flat rate, but it's not flat across all probates. It is based on the value of the estate. And so what happens is, and if I could pull up the ethics, I'd show you that our state's not necessarily fond of that. A lot of different counties have in their ethic references that the probate shouldn't be set on a value. And in fact, oftentimes what I've heard people quoted is the max value for a supervised estate formula. So if someone starts saying to you, well, I can charge 6% on the first 100,000, 4% on the next 200,000, and 2% on that. I mean, they'll rattle off this formula, 6421. That in most of the local rules that I've read in the counties that I've done work in is the max value for a supervised estate. Maximum value, the maximum fee charged for a supervised estate. A supervised estate means you're going to court for virtually every decision that you have to make. It's going to be a much more drawn out process because the court isn't just waiting for you to show up one day. Court is going to require filing for a hearing and then waiting for the calendar to have an open spot, notice to be sent to everybody. And there's some built-in delay in that automatically. So I'm not a fan of supervised unless we have to do it, or it makes sense to do it, or someone requires it, because some people can require a supervised probate. But even with that, the court has to approve the fees. Now, the reality is oftentimes courts don't quibble with attorneys. But again, I'll go back to the fact that that formula that I hear referenced out there is not necessarily appropriately being applied. So ask, how is your fee determined? Is it flat or is it based on the value of the estate? And do you have a formula to calculate that? You're not asking for the actual fee, you're asking how the fee would be determined, and that gives you some way to determine if that's an attorney you want to meet with. You may be fine with someone doing that in your estate, but I would tell you that an estate that has, a relatively simple estate that has a house worth a few $100,000 and maybe some money in the bank and some vehicles, the cost is going to be substantially different in that situation where you apply a formula versus a flat rate, but the work's the same. So just be aware of that. The work for the most part is the same. So that's the second. So a flat rate, a value-based rate, and the other would just be an hourly billing. Sometimes attorneys just say, you know what, I'll just do it hourly. You should be able to get an idea of what the hourly rate is that the person charges, and then roughly, is this 15 hours, 20 hours, 30 hours, 50 hours? They're going to have an idea of what a normal probate range of hours would be. So again, you have an idea of what that rate might be. Now, so that's stuff that you can ask on the phone. Some people will be more obliged to share that, some won't. And you can act accordingly. But again, I would say if you decide then to meet with a couple of attorneys, have some standard questions, and again, we have some of those on the How to Hire an Attorney download. But ask the same, go through the same process with each, vet them the same. Now, I will say, if you meet with an attorney and it just connects, I'm not saying you have to go meet with 3, but you want to connect with this person because someone's going to be spending some time with this person over the course of the next several months, if not longer. So again, we may find it very useful to meet with an attorney either as an individual, someone representing the family. We may meet as a family if the attorney's open for it, and we want to understand what the fee structure is and a rough estimate of what those costs might be. So again, attorneys can be very helpful through this process. Many of them, like myself, have gone through it many times. We know what the different nuances of the different courts are, and we can kind of set some expectation even in a very preliminary talk before we know if we have to go through probate. That's the other thing an attorney should be able to tell you fairly early in the process is whether this looks like it's lining up for probate or whether it's not. As it's mentioned in the probate video, married couples in Indiana rarely go through probate when the first person passes, or rarely need to go through probate because of the way assets are owned. We'll talk about how assets are owned and what's in an estate in a future video. But there's a trigger that requires probate. If we don't get there, there are some other documents you may need to do. And then having an understanding of what a small estate expense might be with an attorney, or the series of small estate documents that might need to be completed, affidavits of survivorship, things like that. So again, I would suggest downloading the How to Hire an Attorney brochure, and then pencil down some things that are pertinent to your circumstance, and then chat with a couple of attorneys and see how that works for you. We'll continue on with our list in the next couple of videos. I appreciate you sticking with this. And as always, I should say, if at any point you want to reach out to our office, the number's there on the page. You can set up an initial phone call. If you just want to talk through a couple things, we can set up an initial meeting, and there's not a charge for that consultation. I really want to give you an opportunity to get a solid foundation of understanding with you and under you so you can go forward in a good way. So again, thanks for working through the process, and we'll continue on with the next video as soon as you're ready.